admitting, as we shall be seeking to do here, that the Deputy President was denied a fair hearing. And a fair hearing is cardinal in our administration of justice from time immemorial, even prior to the 2020 Constitution. And the third one is whether the overnight clearances for the replacement Deputy President evidenced a predetermined process compounded by the violations. Whether that was unconstitutional. My Lords, Your Leadership, the motion by the National Assembly was defective and failed to meet the constitutional threshold. First, the allegations and evidence in the impeachment motion at the National Assembly simply did not meet the constitutional threshold of Article 145(1). And you will find that in Exhibit RG1, Volume 1, page 2 to 41, which is the motion. My Lord, in Martin, Nyaga, Wambora, and 3 others, the Court of Appeal held that the facts that prove gross violation must be proved before the relevant constitutional order. My Lord, Your Leadership, my learned friend Dave Wanjiru here, and myself had the privilege of arguing the Wambora case. It is a high standard in presidential systems. Not each, and you'll find that in the Wambora case, our Battle of Authorities, paragraph 45, pages 45 to 46. Not each violation of the Constitution amounts to gross violation. No, the drafters of the Constitution could have said violation of the Constitution or other reasons. No, they didn't. The word gross must carry the true intention of the drafters of our Constitution. This is the Court of Appeal in the Wambora case saying not every violation amounts to a gross violation. The charge must expressly state that the alleged violation is gross and give particulars of the alleged gross violation. Whatever is alleged against a governor, in this case deputy governor, may I say, not just the deputy governor, the law that this court will be laid down or reiterate will apply to the impeachment of the president himself. It's very weighty issues that this court is asked to confront. Whatever is alleged must be serious, substantial, and weighty. There must be a nexus between the person to be impeached and the alleged gross violation of the Constitution or any other written law. The charges framed against the governor or deputy president of the president and the particulars thereof must disclose a gross violation of the Constitution or any other written law. D, the charges as framed must state with a degree of precision the article or articles, even sub-articles of the Constitution or the provisions of any other written law that have been allegedly been grossly violated. Here, my lords, in the case before this honorable court, the allegations were vague, lacking in detail, and wholly unfounded. Besides, the National Assembly erred in failing to apply the threshold and standard of proof applicable to impeachment proceedings, thus violating Article 145. For example, although the court in the Robert Alive as the Attorney General case, which is reported in 2017, 6090, nullified Section 132 of the Penal Code. The court nullified Section 132 of the Penal Code. 5 years before the Deputy President's election to office, ground 8 of the impeachment motion alleged that the Deputy President had violated that nullified law, warranting his removal from office. By impeaching the Deputy President on the basis of a section that had been nullified by this court, what Sigino was the National Assembly sending to the public who had elected the Deputy President with over 71 million votes. This is demonstrative of the casualness of the National Assembly in performing a very important duty imposed by the Constitution of impeachment. And my Lord, you find that authority, paragraph 62, alike case, pages 62 to 63. And although Article 145(1)(b) only applies where there are serious reasons for believing that the Deputy President has committed a crime, in ground 8, the National Assembly resolved to impeach the Deputy President for, among others, violations of a nullified law. The National Assembly then informed the Speaker of the Senate of that resolution, finding that the charge of violating a repealed law had been substantiated. My Lords, Your Leadership, the Senate voted on that impeachment charge on the basis of a repealed section. You find that in Exhibit RG3, Volume 6, pages 745 to 747. And my Lord, although Article 10 on accountability and the allied case opened all holders of public offices to searching public scrutiny, in ground 9, the National Assembly approved the charge that the Deputy President had grossly misconducted himself by publicly criticizing a public security agent. And my Lord, what offense was the National Assembly stating here? What article of the Constitution was the National Assembly stating had been violated by the first petitioner criticizing the NIS director? My Lord, you will see from Article 239, and in fact the NIS Act, that the NIS, under the Constitution, 239, Sub-Article 5, is supposed to be under civilian oversight authority. And the Act itself clearly recognizes that which is why you will find in the NIS Act, it is 206 of the laws of